Okay, very, very good afternoon to everybody. Thank you so much for joining us for what is the final event in this series of Resolve Summit webinars. It's been a fantastic week of webinars, and we've got another exceptional event lined up for you today with two fantastic speakers from Forbes Solicitors. Those who have been with us all week, I'm sure you're getting really tired of seeing my face and hearing my little intro, but I'm going to have to do it one more time, I'm afraid, and then you won't have to hear from me again for a little while. For those of us who haven't been able to make all the sessions, but you'd like to, you can catch up on our website. I'll do an email follow up and I'll link to all the different recordings so you can catch up on every single event from this series. So we do have a couple new people with us again today, so I'm going to have to tell you a little bit about Resolve. I know most of you know who we are and lots of members with us today, so it's great to see you all here. Thank you for joining us. Resolve is the UK's leading community safety organisation. We've been going for 28 years now, and we're sort of the government's go-to organisation for anything to do with antisocial behaviour. So we're a collective of over 200 different organisations, mainly in housing, local authorities, some police forces and other agencies as well. And we all work together to shape and influence national policy around antisocial behaviour, basically to make sure that it's working for us, that we have the tools and powers we need and that we can serve our communities effectively. Those who are members know that our membership program provides access to things like support, tools, resources, events and trainings, a bit like today, to help you respond to antisocial behaviour with more confidence and in a way that's more effective and efficient. Today's speakers, we're very, very lucky to be joined by Jenna, who's going to be speaking first. Jenna is a partner and barrister at Forbes Solicitors. She specialises in all aspects of housing litigation. She started her career working for a specialist Legal 500 social housing solicitors firm where she became the head of their ASB team. She's done a few other bits in between, but Jenna is very well known and respected across the sector. Some of you here today probably know Jenna already, and she's well known for her meticulous preparation, assertive drafting, tenacious advocacy, and down-to-earth personal approach, which I'm sure you'll see in just a second. I'll also introduce Kirsty, who's going to be speaking a bit later. So Kirsty is highly experienced in dealing with housing management and ASB. She has higher rights, regularly dealing with her own trials. Kirsty dealt with the first 4 gang injunctions in Salford and was awarded a Divisional Commander's Award from Greater Manchester Police for her work dealing with crime and ASB. Kirsty has been recognised in the Legal 500 for her work representing social landlords and local authorities over the last decade and regularly advises clients on mental health discrimination and the Equality Act. So it brings me great pleasure to introduce our very first speaker, Jenna Time from Forbes Solicitors.
Thank you very much, Tom. I'm not sure I'm quite worthy of that, the introduction, but I'm grateful for all the same. Good afternoon, everybody. What I'm going to do is my first test of the day, which is to share my screen. Bear with me. Hopefully that is working okay, Tom. Is that okay? Looking all right? Fabulous. Well, there we go.
Better than the technical issues we had in our last webinar. So off to a great start.
Seamless. I'll take it. Thank you. Right. Okay. Let me just get these slides moving for you. Well, yes, thank you again, Tom, for that introduction. Kirsty and I are delighted to have been invited by Tom and Resolve to speak this afternoon during their very successful Resolve Summit for the ASB and Health Day. So, as it says on the screen and hopefully in front of you, we're going to be talking about reasonable adjustments this afternoon. So this is just some of the highlights of what we'll be covering in the session. So what is a disability, looking at reasonable adjustments in the context of the Equality Act, and then we'll look at when a request is reasonable, and that's something that obviously internally when you're dealing with cases it's important to know. And then we'll have a look at sort of more practical elements of day-to-day work, how facilitating perhaps communication with the victims of antisocial behaviour can enable that effective reporting, and then looking at perpetrators as well. And as we'll discuss, a lot of cases that we see involve vulnerabilities of perpetrators, so how you can adapt your conversations and the way that you're dealing with perpetrators to make sure they understand the allegations put to them, and how you can best use the work that you're doing to best effect if you are having to take legal action. So as usual, we have our disclaimer on the slide. It's to say, you know, whilst we're lawyers, don't take what we're saying this afternoon as specific legal advice on any given case. If you do have any cases that you need a specific advice on, then obviously ensure that you get the appropriate legal advice when you're looking at, as I say, any particular case. So the focus of today's session is the duty to make adjustments for disabled people, which we'll look at in a moment. And a bit of a spoiler, that is set out in section 20 of the Equality Act. But what I thought was important to do is to look at and drill it back down to basics and have a look at what is a disability. So what it says on the slide, section 6 of the Equality Act of 2010 states that somebody has a disability is if they have a physical or mental impairment. The impairment has a substantial long-term adverse effect on their ability to carry out day-to-day activities. So as it says on the slide, the definition of a disability requires the effects which a person may experience must arise from physical or mental impairment. And these phrases are within the sector given the ordinary meaning. And so it's clear that a disability for these purposes can arise from sort of a wide range of impairments, from sensory impairments, progressive impairments, to mental health conditions and illnesses. And within the definition itself, the requirement that an adverse effect on normal day-to-day activities should be a substantial one, as it says in the definition, requires the general understanding of disability as a limitation that goes beyond the normal differences in ability that may exist among society. A substantial effect is therefore more than minor or trivial. And it looks at what somebody can't do as opposed to what they can do. The simple fact that perhaps a tenant can only carry out normal day-to-day activities with difficulty or with pain does not establish within the definition the disability is made out. And when you're looking at the requirement for the impairment to be long-term, as it says on the slides, this means that the impairment must have either lasted for 12 months, at least 12 months, or when the total period for which it lasts from the time of first onset is likely to be 12 months, or which is likely to last the rest of the person's life. Okay, so let's look at reasonable adjustments then in more detail. So section 20, subsection 3 to 5 of the Equality Act 2010 provides that a person is subject to a duty to make reasonable adjustments for disabled people in 3 circumstances and requirements that are set out on the slide. And to summarise those, under the Equality Act, an organisation must make reasonable adjustments that arise when a disabled person is placed at a substantial disadvantage. Firstly, where there is a provision, criterion or practice, which is called a PCP in practice, which puts a disabled person at a substantial disadvantage. Now, the Equality Act uses the technical term provision, criterion or practice, or PCP. However, the Equality Act itself doesn't actually define what is meant by a PCP. Within, and it's a little bit technical, but Schedule 4, paragraph 2 of the Equality Act, that says that a PCP includes reference to a term of letting, but this isn't going to be the only thing that a PCP can mean. Ultimately, this term should be construed widely so as to include, for example, any formal or informal policies that you have, rules, practices, arrangements, criteria, conditions, and so on. And secondly, as it says on the slide, the second requirement is where a physical feature puts a disabled person at a substantial disadvantage. Now, section 20, subsection 10 of the Equality Act defines a physical feature as a feature arising from the design or construction of a building, a feature of an approach to, exit, or access to a building, a feature or fitting, furniture, furnishings, materials, equipment, or other chattels in or on premises, or any other physical element or quality. And then thirdly, where a disabled person would, but for the provision of an auxiliary aid, be put at a substantial disadvantage. Now, the term auxiliary aid includes reference to an auxiliary service, and an auxiliary aid or service in practice is anything which provides additional support or assistance to a disabled person. And that could include, for example, removing, replacing, or providing furniture, furnishings or other chattels, replacing taps or door handles, replacing or providing signs or notices, or replacing, providing, or adapting, for example, a doorbell or door entry system. And if the adjustment that is requested requires the provision of an auxiliary aid or service, the service provider must take such reasonable steps to provide it, as we will see in the coming slides. But for the purposes of the housing sector, it is only going to be the first and the third requirements that are set out on the slide that apply to landlords in relation to lettings and subletting. Therefore, you don't have a duty to alter a physical feature, and that is why the first and third are underlined there for you. That being said, whilst there is the rules, there are always exceptions. The Equality Act does contain a number of exceptions to the rules that I've just mentioned, as well as further provisions in relation to reasonable adjustments where those relate to the structure or the interior of a residence. There is also a sneaky fourth requirement in relation to landlords too that we'll have a look at in a little while. Finally, just before we move on, as it said on the slide at the bottom, the case of Hainsworth and the MOD confirmed that the duty to make reasonable adjustments only applies to the disabled person themselves and does not extend to those associated with a disabled person. Now, this was an employment law case, but you tend to find that a lot within the Equality Act, that it's not simply housing cases that apply to housing. You can look at different sectors, such as employment, which assist, and the principles from those cases apply to housing. So this was an employment law case which said that the Equality Act did not require employers to make reasonable adjustments for an employee who is not disabled, but who claims that reasonable adjustments should be made by their employer to accommodate difficulties in the workplace caused by them, by their association with a disabled person. So when you're looking at reasonable adjustments in the context of housing cases, we're very much focused here on the occupiers of property. That does not just mean tenants, but when we're looking at, for example, tenant or occupier, they will fall within the definition, and you would be looking at reasonable adjustments if they were requested, but not perhaps for visitors. Okay, clarifying some of the terms then. In premises cases, which will fall within part 4 of the Equality Act, which will be the focus of today's session, rather than part 3 of the Equality Act, which makes it unlawful to discriminate for the provision of goods and services, the disabled person must be placed, as I've mentioned previously, at a substantial disadvantage in relation to, firstly, the enjoyment of premises, and secondly, the use of a benefit or facility, entitlement to which arises as a result of the letting. So what I've done is highlighted some of the key phrases on the slide there, because it's going to be important in practice to understand what those words mean. So looking at substantial disadvantage first, as a starting point, a disabled person will need to identify a PCP, for example, which is something that requires particular care. Because in practice, if you have an individual who is disabled who fails to identify the PCP correctly, that risks invalidating their claim of comparative substantial disadvantage. So to succeed in a claim, the disabled individual must show that the PCP places them at a substantial disadvantage in comparison with persons who are not disabled. And the substantial disadvantage, as it says on the slide, is defined as more than minor or trivial. It doesn't require a strict comparative exercise, necessary that you may see in other areas of discrimination, and it is often readily discernible from the nature of the disadvantage itself. So if we look at the case of Fareham College Corporation and Walters, the court held that in many cases the facts will speak for themselves, and the identity of the non-disabled comparators will be clearly discernible from the provision, criterion or practice found to be in play. So the statutory comparison simply involves asking whether the PCP in question puts a disabled person at a substantial disadvantage compared to persons. PCP may, for example, involve stress, anxiety, or other detriments for the non-disabled individual. But like it says on the slide, if it bites harder on the disabled, then the duty is going to arise. And then if we have a look at enjoyment of premises, the Court of Appeal has considered the meaning of enjoyment of premises for the provision of an auxiliary aid for disabled people in the case of Beadles and Guinness North, which is set out on the slide. And within this case, the court held that the word enjoyment meant no more than the tenant should be able to live in their home as would any other typical tenant. So the reference to enjoyment is therefore wide enough to include anything which relates to quiet enjoyment of the property and includes reference to the occupier's continuing occupation of premises against the threat of eviction by the landlord. But on the other hand, there is a case of Thomas Ashley and Drum, and the Court of Appeal declined to order an adjustment in this case, which is particular of interest to me. It was to do with a variation of a no animals clause, so as to permit a disabled person to occupy the property together with their dog. And in this case, the Court of Appeal declined to make an adjustment since the dog, whilst it was described by expert evidence as essential for the tenant's mental health, wasn't in fact a guide dog. And as the dog wasn't a guide dog, the court found that the dog was what was described as an incidental benefit, and it was there only to assist the tenant's state of mind rather than her use or enjoyment of the property. And so there was no failure to make reasonable adjustments. The court even went so far as to say that the death of the dog would not make it unreasonably difficult for her to occupy her home, which is a dog lover I find a particularly harsh comment. So there's differences here, stepping back for a moment when considering indirect discrimination, which would, in that particular case that I've just mentioned, involve a policy which prevented tenants from allowing animals to live with them if it therefore disadvantaged those who would benefit from assistance dogs. But obviously this isn't going to be the focus in direct discrimination of what we're discussing today. So it's just to demonstrate that your indirect discrimination and your reasonable adjustments may find themselves in different situations in these particular cases, but I'll leave indirect discrimination there for now. But before we move on from this slide, what it's worth bearing in mind is that it is not possible for service providers to justify not making adjustments that are reasonable when they relate to the enjoyment of the premises or the use of a benefit facility to which the tenant or occupier of the premises is entitled to have as a result of the letting. And ultimately, the test as to whether the disabled person is able to enjoy premises is whether the adjustment would enable them to live in an ordinary way, as would any other tenant of the premises. Okay, so when to act? As I've mentioned earlier, the section 21(2) of the Equality Act says that a failure to comply with a duty to make reasonable adjustments amounts to discrimination against a disabled person. So this should be really at the forefront of your minds. In Part 4 cases, unlike other areas of discrimination law, the duty to make reasonable adjustments will only apply when the occupier has requested that A, so for example, as it says on the landlord on the slide, take steps to avoid the disadvantage or provide the relevant auxiliary aid. Therefore, the duty to make reasonable adjustments in relation to premises doesn't apply unless and until you receive a request to do so from the tenant or a person entitled to occupy or somebody on their behalf. There isn't, interestingly, a formal requirement specified as to the manner of the request. It doesn't even need, for example, to be in writing. So accordingly, what we see in practice, and you may have experienced as well, is there's nothing preventing a disabled person from making the request for the first time in a letter before action, for example, or within a defence and counterclaim when you've issued proceedings, depending on the specific facts of the case. And interesting, there isn't also a requirement that disabled person set out precisely what specific adjustment is needed, although it's obviously likely to assist their case if they do set out or at least indicate what adjustments they require with some clarity. So, like I've just mentioned, and we'll summarise on this slide, if you are requested to do so by a disabled person put at a substantial disadvantage, a landlord, as it's A in this, must make reasonable adjustments to a PCP, make reasonable adjustments to a physical feature, provide an auxiliary aid, or consent to the making of disability-related improvements to rented residential premises by the tenant unless that request is unreasonable. And that fourth bullet point on that slide is the fourth requirement that I mentioned a little while ago. So as it says, and just to reiterate on the slide, by section 21(2), a failure to comply with the duty to make reasonable adjustments will amount to discrimination against a disabled person. And if we were to look at that in the context of possession proceedings, for example, if a landlord failed to make reasonable adjustments in taking steps for the purpose of securing a disabled tenant's eviction, then the tenant may well then be discriminated against and will have a defence to those proceedings. So looking at that fourth bullet point in a little more detail then, the Equality Act 2010 does provide for a procedure which is set out under section 190 and schedule 21 of the Equality Act to enable a disabled tenant or occupier who occupies a property as their only or principal home to seek landlord's consent to make, as it says there, a relevant improvement. There are some exceptions to where this applies, so these provisions don't apply to rent-out tenancies and secure tenancies, as they largely replicate existing powers within those areas. Equally, they do not apply in respect of other tenancies if the respective tenancy already contains rules as to how to obtain a landlord's consent. So looking at relevant improvements then, which you may have seen be requested by tenants of yours, a relevant improvement is going to be one having regard to the disabled tenant or occupier's disability. It's likely to facilitate that person's enjoyment of premises, i.e. a disability-related improvement, and can include an addition to or alteration to fixtures and fittings, an addition or alteration connected perhaps with the provision of services to the property, the erection of a wireless television aerial, or the carrying out of external decoration. Now, unlike what I was just saying about there being no general formal requirement as to the request for a reasonable adjustment, when an individual is seeking for an improvement to be made to the property under these specific provisions, the request does have to be made in writing. So when the disabled person applies in writing for the landlord's consent, the landlord under these rules must not withhold this consent unreasonably, as an unreasonably withheld consent will be taken as having been given. So it's an unusual rule here. However, you can, as landlords, impose some reasonable conditions. So when a landlord refuses consent, they must give the tenant or the occupier a written statement of reasons why they've withheld consent. And just as a final comment here before we move on, the costs of these adjustments cannot be passed on to the disabled person unless expressly authorised to do so under the Act. So if you are in a situation where you've been requested to agree to alterations or improvements, looking at section 190 and schedule 21 of the Equality Act really very carefully is going to be imperative for you. Okay, so we've been looking, let's return back to sort of reasonable adjustments again. A big question for this session, as we set out in one of the first slides, is what is reasonable when we're looking in the context of reasonable adjustments? Well, as lawyers, we sometimes just say, well, it could be this, it could be that. This is one of those cases, unfortunately. So reasonable is going to depend on your particular circumstances of each individual request. So there is not a one size fits all approach to what is reasonable. And again, the Equality Act not helping us in this situation doesn't define what reasonable is, but there's guidance from the Equality and Human Rights Commission Acts, which suggests that the most relevant factors, which are set out on the slide there, is firstly the effectiveness of the adjustment in preventing or reducing the disadvantage to the disabled person. So the adjustments should be designed to address the disadvantage that is meant to overcome. And in terms of an effectiveness of a step, case law, again from employment law, establishes that for liability purposes, it is sufficient that the proposed adjustment has a prospect of alleviating the disadvantage. So there's therefore no requirement for it to be a straight guarantee of success. And secondly, looking at practicality of the making of adjustments, it may not be possible for you, for example, to provide additional time to customers if you've got, for example, legislative deadlines to meet. So practicality is something that is going to be important in any particular case. Then resources, and this is something that we see quite frequently when requests are coming through. So it's availability of resources, which will include external assistance and finance, the big F word for the purposes of this. So resourcing, when we're looking at this, is not just about cost, though. It may involve, like I've mentioned, some other factors. So in practice, the reasonableness of an adjustment will be evaluated against the resources available to your specific service. So what that means is that what may be considered reasonable in a very large organisation may be different for a small or individual landlord. So it's going to be about what is practical in the specific service provider's individual situation and what that you may have. And whilst some resources and reasonable adjustments may have little or no cost or additional resourcing requirements, they would be relatively easy to implement usually, that in our experience. You will not be required to make, as we'll come on to a little bit later with Kirsty, reasonable adjustments that are unaffordable or impractical to make. And the Equality Act and Human Rights Commission Equality Act Code of Practice accepts that the lack of resources can potentially be a reason for refusing a reasonable adjustment. And it goes on to qualify, however, that the resources available to the service provider as a whole are likely to be taken into account, as well as other demands, like I've mentioned, on those services and resources. Whilst the resources of a service provider are spread across more than one business unit or profit centre, the demands on them are all likely to be taken into account when assessing resources. That being said, there was a case in 2017 of Collins, Secretary of State for Justice, and in that case, the Supreme Court held that budgetary considerations alone cannot justify discrimination. So it's something to consider. And again, you see differences in the case law here as well. And then finally, disruption to service that making an adjustment may cause. There is also, just for the purposes of burden of proof, within section 136 of the Equality Act, once a duty to make a reasonable adjustment has been established and a potential reasonable adjustment is identified by the claimant, so the tenant, for example, the burden of proving it is not reasonable, so it's not a reasonable adjustment, will shift to you as the defendant, and that is going to be an objective test to consider. Subjective opinions of you, perhaps as landlord, even if you've believed that you've taken sufficient steps, is going to be largely irrelevant, unfortunately. So what I'll do now to continue to look at reasonable adjustments in practice is pass over to Kirsty.
Thank you very much, Jenna. I
Kirsty,
am now going to attempt to share my screen.
Sorry. Thank you so much for that, Jenna. That was fascinating and very, very informative. I learned a lot there. Just a reminder to everybody to get your questions and comments in on the chat, and we'll come to them at the end. But thank you very much, Kirsty.
Thank you. Thanks ever so much. So looking at reasonable adjustments in practice, and as Jenna mentioned on the previous slide, in order to be reasonable, an adjustment doesn't need to be guaranteed of success. So it's sufficient that there's at least a real prospect that it would have made a difference. And the case on the slide there is Pawley and First Group PLC. That was from 2017. So when we're looking at reasonable adjustments in practice, the explanatory notes to the Equality Act 2010, Schedule 4, give an example of a reasonable adjustment which is set out on the slide. So this is where a landlord, and I'm sure many delegates will recognise this, a usual practice of notifying tenants of rent arrears in writing, with follow-up visits if the arrears are not reduced. And in this example, a learning disabled person may explain to the landlord that they can't read standard English and wouldn't be aware that they're in arrears. And here the tenant asks to be notified of any arrears either in person or by telephone. And the landlord arranges to visit or telephone the tenant, the learning disabled person, to explain that there are arrears in rent. And the personal contact there would be a reasonable adjustment for the landlord to make. And under the first requirement, which, as we saw earlier on, is a requirement where a provision, criterion or practice, it's often referred to as a PCP, of A's, puts a disabled person at a substantial disadvantage in relation to a relevant matter in comparison with persons who are not disabled, to take such steps as is reasonable to have to take to avoid the disadvantage. And the tenant or the occupier has to show that there's a PCP, so provision, criterion or practice in place. So part of this task we've already seen is to identify that PCP with particular care. So in some cases, as Jenna mentioned earlier, the PCP may well be a policy contained in a document. So in antisocial behaviour cases, for example, the PCP could be your nuisance policy. And often what we'll find in practice is that the PCP isn't the policy itself. It could just be unspoken assumptions that underpin the policy. So for example, if we use the nuisance policy that we've just mentioned, the PCP could be that if the tenant's nuisance reaches a certain level, often it's an unarticulated threshold of seriousness, and you as the landlord will take steps to evict that individual. So sticking with the nuisance policy example, the existence of that within your organisation doesn't on its own cause a disadvantage to a disabled person, but the practice of seeking to evict tenants who breach the policy, which would potentially cause disadvantage to disabled occupiers, and that's either because their impairment such that it reduces their ability to control the behaviour, or because their impairment makes them more vulnerable to the consequence of eviction. So if we return to looking at rent arrears, there might be two PCPs that are relevant to the issue of reasonable adjustments. One, the requirement to pay rent as contained within the tenancy agreement, and then two, your policy or procedure in respect of rent arrears, including any informal practice as to when possession proceedings are issued. And it could be argued that either of these PCPs is capable of putting an individual with a mental health or learning disability, for example, at a disadvantage compared with to those without a disability. So the disadvantage in this particular example would be the exposure to possession proceedings. However, the key issue in such cases is likely to be the identification of adjustments and the reasonableness of those adjustments. So it's highly unlikely, for example, that a reasonable step would be to ask you to waive collecting the rent from the tenant. There may be certain circumstances where that is appropriate. So, for example, if you've got a tenant with a terminal condition, But instead, the court's more likely to be concerned with how the disabled tenant can be helped to pay the rent or clear the arrears. So in that example, reasonable adjustments could consider things like reminder telephone calls, a designated point of contact, attending the property, authorising a third party to assist the tenant, and finally a referral to a support organisation who can assist with managing finances. And if we step away from housing for a moment and look at workplace contexts, the transfer of a worker to a new workplace and alteration of working hours, and that was in Cosgrove and Caesar and Howe, the provision of equipment such as providing adapted chairs, phones and shelves, that was in Foo and Camden, and the variation of work duties to include less stressful non-contact hours, and that was in Nottinghamshire County Council and Michaela. They've been all treated as reasonable adjustments. So while some of those activities don't have direct application within housing law, for example, the equivalent of a transfer to a new workplace could be the relocation of a tenant to a new premises, for example, and an equivalent of variation of work duties could be the variation of terms under which the tenant makes payment to cover their rent arrears. So just moving the slide on. So treating more favourably. The duty to make a reasonable adjustment can extend to treating a disabled person more favourably than a non-disabled person. And that principle was established in the case of Archibald and Fife Council. That was back in 2004. And the case concerned a road sweeper who underwent minor surgery, as a result of which she was left unable to walk. She became unable to carry out her duties, and they obviously required her to be physically fit. The council explored whether there was any alternative work available for which Mrs. Archibald was suited. And a number of alternative sedentary posts were identified, but they were at a higher pay grade than the grade of the road sweeper. And under the council's redeployment policy, in order to be selected, Mrs. Archibald had to be chosen at a competitive interview. And she unsuccessfully applied for over 100 alternative positions without any of her applications succeeding. And in the words of Lady Hale, which are on the slide there, the duty entails a measure of positive discrimination in the sense that employers are required to take steps to help disabled people, which they're not required to take for others. Also, in the case of Lewisham London Borough Council and Malcolm from 2008, Lord Brown accepted that the same principle applies to landlords. So in certain respects, a landlord must treat the disabled more favourably. He must make reasonable adjustments in relation to the premises. So that obviously is worth thinking about. So to look at some case examples now. The focus of the landlord and ultimately of the court must be on the PCP complained of and the detriment suffered by the disabled person. So looking at how this works in practice with some examples, in Lindsley and Revenue and Customs Commissioners, the respondent failed to accommodate a disabled worker who asked for 2 reasonable adjustments, a parking position near toilets and a reserved parking space. And on the matter before the court, the respondent was applying a PCP and it caused the claimant disadvantage, the stress of having to search for a parking space. And the Court of Appeal held that the respondent had failed to make a reasonable adjustment when it agreed to meet the first, but not the second of those needs. And an injunction case, which is on the slide there, Hastow Housing Association and NB, and this was at the County Court in Oxford. Judge Clark held that the legitimate aim of protecting the landlord's staff, residents and visitors could have been achieved by adjustments rather than an injunction, which would be disproportionate. So just pausing there, as any of you that deal with possession proceedings will know, an alleged failure to make reasonable adjustments can also be used as a defence to possession proceedings. And we see this quite a lot. It's certainly attempted anyway. And obviously we could spend a day dealing with this, so we'll just look at one example case this afternoon. So in Heart of England Housing Association and M from 2018, the court dismissed the possession claim where the tenant suffered from paranoid schizophrenia, and medical evidence confirmed that many of the allegations of antisocial behaviour were linked to the tenant's disability. And in that case, the district judge found there was evidence that the disability could have been managed with support, and that the landlord, who was a social landlord, had not done enough in terms of engaging the relevant support networks. So just from these examples, it's clear that you need to consider reasonable adjustments very carefully when they arise and ensure that any action that you're taking is proportionate and that you've done all that you can to support the tenant. And as it mentions at the bottom of the slide, it's worth mentioning the Human Rights Act here. Again, we could take a whole day on that subject as well, so we don't want to dwell on it too much for today's purposes. But the Human Rights Act will need to be considered when you're assessing reasonable adjustments. And as you may well be aware, the Act sets out the rights and freedoms that must be protected and applied without discrimination. And the Act states that discrimination occurs when you're treated less favourably than another person in a similar situation, and this treatment cannot be objectively and reasonably justified. And so we've just mentioned that needs to be considered as well when you're in a situation that involves reasonable adjustments. So looking at some recent case law that involve reasonable adjustments, and this will be important if you find yourself in a similar situation. So in the case of R and Kensington and Chelsea, the court held that the council had not discriminated against a disabled tenant who had heightened sensitivity to noise and smell. And the tenant in the case was FG, and they were disabled within the meaning of the Equality Act 2010. They had a diagnosis of various serious mental health conditions, one of which was paranoid schizophrenia, which caused heightened sensitivity to noise and smell. And FG had been a secure tenant of Kensington and Chelsea since September 2021, after which they became homeless and lived in a third-floor flat. And soon after moving in, FG began complaining about the noise from the flat below and the smell from their own flat. FG complained to the council that this was interfering with their ability to enjoy the property and was hampering their recovery. And the council undertook investigations into FG's complaints and concluded that the issues did not amount to a statutory nuisance. FG disagreed and obtained their own expert evidence, which stated that works could be carried out in order to address the concerns that were being raised by FG. And having considered the evidence, the council declined to undertake the works as they were found to be expensive and disruptive. And FG brought a judicial review claim, claiming that the council had discriminated against her by not complying with its duties to make reasonable adjustments in respect of noise and the smell that they'd experienced. And FG also claimed breach of the public sector equality duty, which is contained within section 149 of the Equality Act. And the High Court, when it dismissed the appeal, held that the council hadn't breached the duty to make reasonable adjustments. While the court found that noise was in range of normal tolerance and that FG was at a disadvantage compared to somebody without the condition, the court held that FG was hypersensitive to noise and smell due to her psychosis, and the council had taken reasonable steps and that no reasonable adjustments could be made without great expense and reducing the size of the flat. And so as a result of that finding, the council hadn't breached its obligations under the public sector equality duty. And ultimately the solution was for FG to apply for a transfer to another property. So that's quite a useful case to be aware of. So looking at how facilitating different ways of communication can enable effective reporting. So now we're going to take some time to look at some practical tips you can use when you're dealing with vulnerable victims and also perpetrators of antisocial behaviour. And supporting victims is a vital part of ASB casework. And the process starts really by making sure that if someone's experiencing ASB, it's easy for them to report the problems to you as their housing provider. And this may mean having a variety of different methods for doing so. It would commonly include telephone, email, reporting in person, in writing, and through social media. But additionally, you should also think about making sure that those methods are accessible to everybody, including people whose first language isn't English, or those who have learning difficulties, disabilities, or vulnerabilities. So, for example, if you have a disabled resident who's unable to use a noise app, which is becoming increasingly popular, providing them with the good old-fashioned diary sheets may be a more appropriate solution for them to capture the incidents as they happen. And if you have a tenant who would prefer to have a specific point of contact to report issues, consider whether this is viable in your organisation, and if it is, provide that victim with a single point of contact. Alternatively, if you think it may assist the disabled victim to make reports through a third party, that should also be considered. And you could also think about increasing your support offering to victims of antisocial behaviour who are disabled or vulnerable. So calling it to check in with them more frequently, or popping in when you're on an estate walkthrough, are all things that you can do to support the victim who may, through vulnerability or disability, struggle with the court process, and also the reported issues more than a tenant who doesn't have the same disability or vulnerability. So, moving on to the next slide. So now we're going to look at ensuring perpetrators can understand allegations to help keep communities safe and free from antisocial behaviour. So if the victim in an antisocial behaviour incident is particularly vulnerable, it's likely that the level of action in relation to the incident needs to be of a higher level than if the same behaviour was being exhibited towards someone who's not considered vulnerable. That's all well and good, but what happens, however, when your perpetrator of antisocial behaviour is vulnerable? And sometimes you get vulnerabilities on all sides. And in cases of ASB, it's very common for the perpetrator of ASB to have their own vulnerabilities. And we often see injunction and possession claims that are defended on Equality Act grounds. Antisocial behaviour and mental health issues can be intrinsically linked. So, for example, somebody with schizophrenia may have auditory hallucinations, so they're hearing things, which causes them to scream and shout in the property. That in turn causes nuisance to the neighbours. And while it's still true that the needs of the victim should be at the forefront of your decision as to how to manage a particular case, it's also necessary to consider the needs and requirements of the perpetrator. It's unlikely that the behaviour will change without some sort of positive intervention, and that doesn't always mean legal action. So it's vital that your organisation helps and supports a perpetrator of antisocial behaviour as much as you can to try and understand the allegations and work together, and bringing in external third-party agencies when needed to work towards resolving the matter without resorting to legal action if this is possible. And we've seen increasing numbers of cases involving complex mental health conditions or disabilities that manifest themselves in unusual or complex ways. And in these instances, we're routinely encouraging clients to enrol themselves on specialist courses to learn about the intricacies of certain disabilities or vulnerabilities, so that officers know how to best approach and communicate with tenants with specific conditions in an understanding way that doesn't cause distress. So, for example, I have a case at the moment where my defendant is autistic, on the autistic spectrum, and their single point of contact at the organisation has been an autism awareness training. So that has really helped the communication between the two. And if legal action is ultimately taken as a last resort where other non-legal interventions have failed, given that vulnerability may well form part of a defendant's defence, as we've explained, you'll likely get defences from the Equality Act 2010. It's vital that you've completed a fully informed, impartial and comprehensive proportionality review before you take any legal action. And if you have been on a course, as I just mentioned, which has assisted you to understand the defendant's vulnerabilities in a much clearer way, this should and usually is taken into account by the court when considering the actions that you've taken and why, for example, you felt it was necessary to proceed with a claim for possession. So I think that concludes certainly everything that Jenna and myself wanted to say. Thank you very much for your time. We've got a little bit of time left now, so perhaps I could open up for any questions.
Wow, what an unbelievably informative, interesting and helpful webinar, I think, to bring the Resolve Summit series to a close. Thank you so much for that. We do have a few more minutes, so if anyone wants to send their questions in, you can put it through the chat and we can read them out. It's worth mentioning that there's so much helpful stuff there. You can refer back to this at any time. We're going to upload a recording of the whole webinar onto our website. I'll send a link out. We're also really lucky to have you both presenting at our national conference in March in person, in real life. So we'll be having a really interesting workshop from Kirsty and Jenna then as well. Does anybody have any questions though for now? And Kirsty, would you be able to stop sharing your screen, please? I can see my face.
Absolutely, yeah. I got carried away there.
It's horrible seeing your big face reflected at you.
Well, I saw mine in a few places. I thought, oh no, and entered the Twilight Zone. Well, I mean, I don't think there's anything necessarily come through. I think we've sort of given enough information perhaps this afternoon, especially for a Friday afternoon. And I'm really grateful for so many people to have stayed the course and to have listened to us for the past sort of hour or so. If anybody does have any questions at all, I'm sure sort of our email addresses will be put somewhere, but you can obviously find us through the Forbes website as well if you need any specific advice or want to speak to us. Perhaps sometimes these sorts of questions are better over email and whatnot, because some people don't necessarily want to provide too much information in this sort of forum. So you're absolutely welcome to get in touch with myself or Kirsty or any one of our team to keep this conversation going, or if you have any specific questions.
That's brilliant. We will, of course, share your contact details with everyone on the call. And Resolve members, you can also continue the conversation on our Ask the Network online forum on the website. I'm sure there's going to be some heated debates after all the webinars we've had this week on all the variety of topics. But yeah, no questions coming in, just people thanking you for a really, really interesting session. So with that, I think then we'll bring the Resolve Summit to a close. Thank you again so much to Kirsty and Jenna for your fantastic session today. And thank you all for joining us, whether it was just for today or you've been with us for the rest of the week as well. It's been really great to see you all and meet some new faces as well. Thanks very much.
Thanks for having us.
It's been a pleasure, Tom. Thanks so much. Have a great afternoon.
Thank you.
Cheers.
Bye-bye.